Good morning, my ladies and my lords. I have, I think, four very quick points just before I sit down. The first is as to the IS91R forms in their chronological setting, and would it be helpful to have it on a page? You've got it on a double-sided page. It's all referable to the statement of facts and issues and what's in the appendices. You'll see there are in fact 11 IS91Rs. And even if you took Eurodac match as the relevant date, so far as being in the Dublin process is concerned, and I'm not conceding that's the right date, but even if you did, then that trigger date would predate every single one of the IS91Rs, apart from one which was 1 day later, and that's Mr. Mohammed on the back in the middle, 8th of September. 9th of September, and you'll recall the concession in this case, which is that the relevant detention for all claimants at all relevant times was for the Dublin transfer purpose, Article 28.2. Secondly, while we're thinking about facts, just to make clear, and it'll save time for later on, while I'm on my feet in relation to issue 3 and remittal, were Sir James right about everything that we're arguing about in front of you? First point to make is that on the Dublin breach point, I don't mean breach because there weren't prescribed criteria in the right instrument. I mean the detention decisions were not compatible with the safeguards of Article 28, including, but not limited, to significant risk of absconding. The first point to make is that we're in the same position on that as we are on Hardyall Singh. That was a live issue in the Court of Appeal as a question of application of Dublin to all 5 of the claimants. And while Lord Justice Sales dealt with it, the majority did not deal with it. And therefore we don't have a finding from the Court of Appeal on that issue because the majority dealt with the case and said it's enough that this is a breach because there aren't the right criteria in the right instrument. So that's the first point, and the permission to appeals are in the statement of facts and issues at paragraph 10.2 and 10.3. It's all addressed in our joint skeleton in the Court of Appeal. So Lord Justice Sales, when he deals with it at paragraph 130, that's his minority view. So that's the first point. The second point is that there is a difficulty in any event on the face even of what Lord Justice Sales in his dissent says. If you look at page 264, paragraph 49, which is one of the passages Sir James referred you to yesterday, paragraph 49 at 264, in the part of his judgment dealing with the application of Hardyall Singh in relation to Ms. Hemmati, as she is, and Mr. Khalili, Garnham J. reviewed the evidence, found the Secretary of State detained them both on the basis of a concern that otherwise they might abscond and evade immigration control. Even that wouldn't suffice, because it's not a concern and might. It's, as you know, got to be based on significant risk of absconding. And so that's Lord Justice Sales at 1.3 at 49. You then get a similar problem at 81 on page 272, dealing with the IS91R forms, or Justice Sales's view, as it's clear from other documents, they were at various times, Secretary of State considered this is SS, did pose a risk of absconding. Well, depends when you're looking, but even that's not the right test for the same reason. But in any event, it's an objective standard would need to be considered by the court, and we'd need a decision of a majority of the court. There's another problem, which is in saying that Mr. Justice Garnham had dealt with it and made a finding in relation to the 2 relevant claimants that were before him on significant risk of absconding. Even that isn't right. If you look at page 335, what Mr. Justice Garnham had done at 335 at paragraph 115 is to say that there was an entirely reasonable and appropriate assessment of, again, risk of absconding, wrong question, but wrong claimant for our purposes, because that's Mr. Khaled, who is not an appellant before this court. And whilst Mr. Justice Garnham does go on in the later passage to set out sections from the witness statement evidence, not the contemporaneous documents, at 119 on 336, all he actually does is Hardy will sing. So it's very unsatisfactory, but the short headline point is the point I've made. It was in issue in the Court of Appeal and only attracted observations in a dissent, the majority deliberately leaving it to one side. I ought to add this important footnote so far as SS, the anonymised fifth respondent, is concerned, and that is that, as you'll see in the Statement of Facts and Issues at the end of paragraph 8.8 of the Statement of Facts and Issues, Mr. Howell, Queen's Counsel, sitting as a deputy, decided that case on the basis that it was detention for removal, and you may recall had declined permission for the Secretary of State to advance further material. There was no appeal against that, and from SS's perspective, therefore, there's nothing we would say that the Secretary of State would be entitled to contest on a remittal. The issue in SS's case ought to simply be one of quantum for that reason. So that saves me having to stand up at the end for the purposes of dealing with what the remedy would be on the fallback position. And that leaves just 2 points. The first is, I answered a question by my Lord Kitchen yesterday about, and you asked me, what support was there for me saying that recognition by settled case law of objective criteria arising from consistent practice would have met the Strasbourg standard. And I could barely sleep because I didn't answer that question properly yesterday, and I referred you to some passages that simply effectively repeated the point. So I'd like to have another go. The description you'll find, if you go back, please, in Chodor, in paragraph 22, is where I'd started to answer at 1684. And it is important just to start again with this, 1684, paragraph 22, because the referring court was describing recognition in settled case law, beginning of 22, of objective criteria. And then later in that paragraph, you see that that settled case law, which recognised objective criteria, was itself confirming a consistent administrative practice. Now, if we just go back to 1670, you'll see in the Advocate General at 1670, who's dealing with Strasbourg standards, in paragraph AG 40, that the Czech Republic and the UK, who pitched up in Chodor and were a party in the case, I don't know whether or when they got a draft judgment, it doesn't matter, but they were a party, they knew what the issues were, they were arguing it, and dealing with ECHR and standards of law. And if you just have a look at footnote 21, the Advocate General recognises that the European Court of Human Rights had held that established case law constituted a sufficient legal basis for prolonging the detention of a person under 51F. So that's immigration detention. The footnote goes on to say, I'm not aware of any case where consistent administrative practice would itself be sufficient. But of course here, we had the consistent administrative practice was the starting point, but the point that was being made by the Czechs was that those objective criteria have then themselves been recognised in established and settled case law. So that's my answer as to why and why on the face of it. Now, one can dig just slightly deeper in this way. I'll do it very, very quickly. Sunday Times is the famous case that established that common law, settled case law, could satisfy ECHR prescription standards. I'll just give you the reference. It's 3415. It's 3415. And the key passage in Sunday Times is paragraph 47 on 3415. It's volume 6, tab 63. Meaning of law for Strasbourg in prescribed by law. And there's a passage in Strasbourg in 1979, in the middle of that page 3415, where they're saying it'd be contrary to the intention of the drafters of the convention. If it had to be in legislation, that would deprive a common law state who's a party of the protection and strike at the roots of the state's legal system. So that's why they're saying at the beginning of 47 it covers not only statute but also unwritten law. And Sunday Times itself is a case then where it was settled case law that sufficiently met the standards. You see that at the top of the next page as to the standards and the bottom of the next page as to the standards. Now, I'll just take two other very quick steps with this. The second step is to go to 3465, and 3465 is Croslin and France. And Croslin and France at the top of 3465 in paragraph 29 is discussing Sunday Times, but is making the point that it's good for common law systems and it's also good for civil law systems. It's not just the UK, but also the Czech Republic who'd be able to make the point. Don't exaggerate the difference between the two. That's the thrust, referring to Sunday Times, of Croslin at the top of 3465. Now to complete the steps, if we go back to Chodor, you'll see in the court's judgment at 1684, in paragraph 21, that 1684, paragraph 21, towards the end, the court, as did the Advocate General before them, are citing, by reference to other sources of law, 5 lines from the end of paragraph 21, Croslin, paragraph 29. Croslin is citing Sunday Times, paragraph 47, civil law, common law, a source in settled case law in principle satisfies ECHR standards, even in the context of detention and 51F. So that is, I hope, at least a better answer than the one I gave yesterday, and perhaps I'll sleep tonight. The next, then, quick point is that I said to you yesterday, there is a paragraph in the guidance that does deal with risk of absconding. It was actually conspicuously absent from the Secretary of State's printed case, where the relevant passages from the guidance were all listed, although it did feature in Sir James in his oral submissions yesterday. And it's a paragraph that the Court of Appeal majority discusses at page 297, at paragraph 173. And they explain why it can't possibly suffice for the purposes of Dublin standards and Chodor. But it might just be worth looking back at the paragraph itself. It's at page 1289, which is volume 1 of the authorities at tab 2. And just 3 or 4 quick points to make about this in its setting. The paragraph on risk of absconding is at the bottom of 1289. It's got a bold heading, risk of absconding, and there's then 2 paragraphs before you get to risk of harm. This passage is dealing with criminal casework cases, and you'll see that from the main heading at the top of page 1289. And criminal casework cases, as you'll know because you've had many of them, are deportation of an offender who's coming to the end of their sentence. And that's the point being made at page 1287, under a bold heading, further guidance on deciding to detain in criminal casework cases. In the next paragraph, 55.321, it's this a type of cases where you've completed a custodial sentence, you're then in immigration detention with a view to your deportation. And it's in that context that you then get imminence, 1289. If removal is imminent, usually appropriate to detain, that's the beginning of the first complete paragraph on 1289. And then you get risk of absconding. If removal is not imminent, you should consider risk of absconding. And then there are references about the seriousness of the conviction, and then some references to past failure to comply, behaviour in prison, family ties, not forgetting the welfare of a child, and then towards the end of the second paragraph, a reference to a sliding scale. The greater the risk of absconding, the more likely it is that you can justify detention, but the fact you haven't got documentation is not sufficient. Now, that cannot, of course, as the Court of Appeal said at 173, page 297, be compliant, but it's the closest we've got to a paragraph that is dealing with risk of absconding. It can't be compliant because it's clearly not Dublin. It's definitely on its face not Dublin. And it's not a framework of certain prescribed limits, even leaving aside binding provision of general application. The other points are the points that are made by the Court of Appeal at 173. At page 297. And again, it rather begs and illustrates the fact that there are choices to be made when you get into risk of absconding as to what's going to be relevant. And as you know, our position is that those choices are for a rulemaker when you are looking for the criteria for all the reasons that we've articulated. And we've had warning that you're going to be handed by Sir James in his reply a document from the Commission on the Returns Directive, and there's a passage on risk of absconding there, and it fits the point I've just made perfectly. I may need to stand and make I'm not sure what point he's going to make, but you'll see, ironically, the Commission saying Chodor and 2N means you have to have risk of absconding on objective criteria fixed in national legislation, but what follows in the relevant passages, the Commission are recognising that it is the choice of the member state to determine the criteria, fixing them in the national provision. In other words, it's the rulemaker who is making the choice as to identifying those objective criteria.
So you're reading from a document that we don't yet have?
Yes, that's right. I'm just trailing it because it fits, and I'm hoping to save time later, because if you've got that point in mind, maybe I can stay in my seat. Those are my submissions, and I'll now hand over to Mr. Southey.
I've got a question that will seem extremely trivial, but I'm interested in the genesis of the 2017 regulations. 8 minutes ago, you said, I don't know when the government would have received the draft judgment in El Chodor. Yes. You would know, above all people, Mr. Fordham, how much before promulgation of a Luxembourg decision the parties get the judgment. And what's the answer?
It's a factual question that you're asking me, and my factual answer to your question is I do not know. And I take on the chin, whatever that means about me and my expertise and experience. But what I do know is there is at least one passage, and I think it's the Court of Appeal, which says presumably the Secretary of State will have seen a draft.
Well, yes.
And I'll try and find that passage. But I can't tell you.
You can't, okay.
So I'm sorry, I'm afraid that's a disappointing, but nevertheless...
Don't worry.
Answer.
Thank you.
My ladies and my lords, I'm obviously not going to repeat Mr. Fordham's submissions on issue 1, but I would, if I may, start by making 2 short points intended to supplement those submissions. The first is this. In my submission, there is good reason why the CJU held that Article 2N is intended to go further than the ECHR. When one comes to look at damages, as I will in a moment, one of the principles that will crop up in my submission is that the ECHR essentially is a general principle of EU law. And one sees that in two sources. If one goes to volume 2 of the authorities, tab 14, firstly, at 1964 memory stick, one sees, unsurprisingly, this is the Charter of Fundamental Rights, that one of the fundamental rights safeguarded by the Charter is the right to liberty. Now that right needs to be interpreted in light of Article 52.3 of the Charter, going further in the Charter, and then 1973. And that holds that the rights in the Charter corresponding with ECHR rights should be given at least the scope of those rights. I say at least because there is other provision that recognises essentially that the EU can go further. So the Charter recognises a right to liberty, which at the very least has to reflect the ECHR. That's consistent with the second provision, second source. Go next tab, memory stick 1980, the Treaty on the European Union, Article 6.3 provides that fundamental rights guaranteed by the ECHR are general principles of EU law. So if effectively Dublin 3 said nothing, didn't have a provision equivalent to Article 2N, one would still have ECHR standards. So the implication is by saying something, by requiring the state to specify in accordance with Article 2N the risk of absconding, the European Union is intending to go further than the ECHR because, as I say, the default position is ECHR standards apply. The second point I'd wish to make in relation to point 1 is responding to a question of Lady Arden, think of Sir James. My lady referred to, and it may be worth having it to hand, if one goes to Appendix 3, page 863, that's an example of the IS 91 form that we've seen. And the lady asked Sir James, essentially, whether the statement at the top of that form, if one has that form to hand, that detention is only used when no reasonable alternative is available, essentially implied that there needed to be a risk of absconding. Now, I submit that doesn't imply that there needs to be a risk of absconding. If one goes to the EIG, which is volume 1 of the authorities, tab 2, relevant page 1300, one sees 3 paragraphs into that page.
Sorry, could you give me the page again?
Sorry, 1300.
I was writing down what you said, you see, and then didn't have time to write down the page reference. Thank you.
It's my failure to give the page reference, so I'm...
Yes.
One sees sort of 3 paragraphs into it. It's identified 6 possible reasons for detention are set out in the IS 91. Underneath that, there are 5 bullet points, one of which is risk of absconding, which is the first one. But other matters are identified as being justifications for detention, including removal is imminent. A point that reflects the point my learned friend Mr. Fordham just made, that imminence of removal is a freestanding ground. And that reflects the structure of the form, because if one remembers the form that I took you to a moment ago, there are 6 boxes at the top which can be ticked. one of which is risk of absconding, one of which obviously is imminence of removal. And that reflects the fact that as a matter of domestic law, one doesn't have to have a risk of absconding to detain. If one needs authority for that, looks at tab 5 of the same volume, Lumber, paragraph 51 of the judgment, which is memory stick 1525, cites, it's Lord Dyson's judgment, and it cites Sardi in the United Kingdom, and halfway through the paragraph cited, paragraph 72, just above letter C in the law report, one sees it said there's no requirement that detention be reasonably considered necessary, for example, to prevent the person concerned from committing an offence or fleeing. And that was obviously, my ladies and my lords may remember, Sardi was the case about Oakington, the Oakington system, where people were detained for administrative convenience, essentially. So the decision maker, looking at the form, is led to believe, essentially, that detention needn't be for reasons of absconding risk. That contrasts, if one looks at what happened in the regulations, volume 2, tab 13, 1954, 2017 regulations, Article 4, Article 4 starts by directing a decision maker that what's in issue is a significant risk of absconding for the purposes of Article 28.2. So in contrast to the position before that regulation, as demonstrated by the form, one now has a regulation which starts from the position one has to have a significant risk of absconding. And so whatever the facts of the individual case is, our point about the form essentially is nothing on the form would have directed the decision maker that the reasons, the various factors identified in the EIG to be considered was to determine whether there was a risk of absconding. To the contrary, the form suggested, consistent with everything else, there didn't need to be a risk of absconding. Turn to issue 2, which is damages.
Could I just ask you, before you leave 2017 regulations, do you say that it did set out the criteria, the objective criteria defined by law for assessing the risk?
2017 regulations?
Yes.
I wouldn't necessarily concede that, but I don't, in my submission, it doesn't need to be determined for the purposes of this. My point is, it goes considerably further than the EIG, because it starts from the starting point that there's a need to assess significant risk of absconding in accordance with Article 28. That isn't in the EIG. And as my learned friend Mr. Forden points out to me, that regulation has been read as exhaustive, whereas one has the problem, of course, that the EIG is an exhaustive list.
Quite.
Turn then to issue 2. Yesterday in my submission, Sir James made an important concession on the behalf of the Secretary of State. During the course of argument, he clearly accepted that if his arguments regarding issue 1 were rejected, the respondents had been detained unlawfully as a matter of domestic law. He accepted that the elements of false imprisonment were present. His argument essentially was that this court should adopt a different approach to damages in this context because the origin of the illegality was EU law. Essentially argued, as Lord Justice Sales appeared to find in the Court of Appeal, that it was open to this court to choose to apply EU law rather than long-established common law principles. And my simple response to that is that there are at least 6 reasons why the court should follow long-established principles of common law. Firstly, thinking back to the point I just made, essentially, the common law has applied rules that have become the tort of false imprisonment as a safeguard for liberty over a number of centuries. Second, consistent with that, this court and the House of Lords have both resisted attempts to narrow that common law approach. Third, it's wrong to suggest that the nature of illegality, the illegality raised in this case or identified in this case, is different to that in conventional false imprisonment cases. Fourth, EU law and case law of the European Court of Human Rights recognises the importance of respecting domestic law protecting fundamental rights. Fifth, EU law does not impose an obligation on states to limit remedies to those available under EU law. Indeed, the principle of equivalence can require, and does in this case, require domestic damages to be applied in an EU case. And finally, we do not accept that EU law supports the sort of balancing exercise that was applied by Lord Justice Sales and is argued for by the Secretary of State. Turning to those reasons, can I ask the court to go to Lumber again? Volume 1, tab 5, and the relevant passage I'm going to start at is Memory Stick 1568, the judgment of Lord Collins. Lord Collins, helpfully in paragraph 219, cited the Magna Carta, Statute of Westminster, at the start of his judgment. Now, the reason I draw attention to those provisions is because if one looks at those provisions, such as the Magna Carta, no man shall be seized or imprisoned except by the law of the land, that essentially sets out what is now the law of false imprisonment. If one goes to Lord Dyson's judgment, where the principal approach he applied is set out, Memory Stick 1527, paragraph 65, Dyson's judgment, Dyson's approach, which was then applied by the Supreme Court, certainly the majority of the Supreme Court, is, as set out in paragraph 65, all a claimant needs to do is demonstrate that they were detained. Then the burden shifts essentially to the detainer to demonstrate there was lawful justification. That essentially reflects the Magna Carta. Now, if the tort is established, Lord Dyson also went on to hold, this is also a well-established part of the tort, as set out at paragraph 95, essentially that one needs to suffer loss if one's going to be compensated. The reason for that essentially is at paragraph 93, one's entitled to be put in the position one would be if there'd been no tort. That's important because in my submission, the Secretary of State is in error to suggest that a more nuanced approach was adopted in Lumber, or that the principles of false imprisonment were in some way adapted. All the court did in my submission, paragraph 68, Lord Dyson's judgment,
Page number?
Sorry, memory stick. I knew I'd forget fairly early. 1528.
Thank you.
All the court did was recognise that a public law error needs to be material. Of course, an irrelevant public law error doesn't make the decision to detain unlawful. It doesn't. There's no balance. There's no nuanced approach. This isn't a modification of the basic principle at paragraph 65. It is just a recognition that an error needs to be material. Similarly, in terms of...
Sorry, and by material, Lord Dyson meant bear on and be relevant to?
Bear on and be relevant to. I'm not going to go into the argument about the different judgments, because in my submission, as we've set out in our statement of case, Cambardzi makes it clear that Lord Dyson's approach is correct. A majority clearly adopt the Lord Dyson approach as we've set out. But my key point is, Lord Dyson isn't saying then that there's some special approach to public law error. He's just recognising, essentially, of course, if you have an irrelevant public law error, it doesn't make your detention unlawful.
It has to be causative.
It has to be causative. It's a causation question, exactly, my lady. Similarly, in terms of damages, and of course the Secretary of State's approach is really focused on damages, all Lord Dyson was doing, as one sees in the passages I've already taken my ladies and my lords to, all Lord Dyson is doing is recognising, of course, one actually has to suffer loss. It's just, again, an application of the conventional tort.
To get more than nominal damages.
To get more than nominal damages, one has to suffer loss.
Yeah, it is actionable per se, but you don't get substantive damages unless you've suffered some loss. Yeah.
Yes. Sorry, I was probably shortcutting there, but
No, I was just checking.
So, in my submission, what one sees, if you like, switching from the Magna Carta to Lord Dyson's judgment, is a consistent approach to false imprisonment over many centuries. It hasn't changed. Now, consistent with what I've just submitted, firstly, in Lumba, it's quite clear that attempts to narrow the approach to false imprisonment were rejected. If one looks at paragraph 67 of Lord Dyson's judgment, memory stick 1528, one sees a summary of the Secretary of State's arguments, essentially, as to how a different approach should be adopted. Those submissions, if one looks at them, do bear a close resemblance to some of the arguments at least found in my learned friend's written submissions. In my learned friend's written submissions, for example, he argues there's a discretion in relation to judicial review. But those arguments are rejected, and one sees that at paragraph 68, and then paragraph 70, in particular, the issue, for example, of discretion in judicial review being rejected. So Lumba, in my submission, represents a rejection of an attempt to narrow the approach to false imprisonment. Perhaps an even...
But aren't these paragraphs dealing with the liability rather than damages?
Well,
and hasn't Mr. Eadie, in fact, conceded on the relevant premise liability? And you're supposed to be addressing us on damages. Do you mind my saying that?
Well, of course, my lord, I don't mind. But the point I'm making, my lord, is that if one goes back to the point I made a moment ago, on damages, the principle is clear. One has to suffer loss, but if one suffers loss, one is compensated. My learned friend is again seeking to narrow the approach, and the point I'm making is attempts to narrow the approach have been resisted for good reason, essentially. And that's simply the point I'm making, is that this may be focused on damages, but ultimately it's still an attempt to narrow the tort of false imprisonment, because it's saying essentially that despite the fact that historically, subject to his point obviously about nominal damages being effectively available only on the facts of these cases, he is also adopting a principled approach essentially to damages, and saying the approach to damages should be different because EU law's in place. And
Yeah,
I'm
well,
saying this is a tort that stood the test of time.
Very well.
Attempts to narrow it have been rejected.
Okay.
Can I just draw attention also to Evans, because Evans is another, and one might think is sort of in some senses an even clearer example of a rejection of attempts to narrow damages or attempts to narrow false imprisonment. Ex parte Evans is volume 3, tab 28. And the relevant passage, the starting point is memory stick 2365, which is Lord Staines's judgment. And Lord Staines's judgment is helpful because it sets out the background, because in one sense one might think ex parte Evans is perhaps, from a government point of view, the most compelling case for no damages to be awarded, because the background was the governor, as Lord Staines puts it by letter G.
I'm sorry, which page?
Sorry, 2365 of the memory stick.
Thank you.
Internal page 27. As Lord Staines puts it, the governor was blameless in that case. The governor who had actually detained the prisoner was blameless because they had accurately and correctly applied Home Office guidance. The Home Office was also blameless because it had applied divisional court guidance. But the problem was the divisional court had in fact got the law wrong. Now, the government's submission, unsurprisingly, was in those circumstances we shouldn't be liable for damages because we applied the law as everyone understood it to be at the relevant time. That was rejected. Lord Hobhouse, who goes to memory stick 2385, by letter E. The state, through the legislature, has defined the power of detention. The state, through the executive, has detained the plaintiff in excessive power. It creates no injustice that the state should compensate the plaintiff. It certainly does not make it just for the state to fail to compensate the plaintiff that one or more of the emanations of the state have misunderstood the legislation. Well, we would submit we're in exactly that same territory here. This is essentially a provision which is part of domestic law, except obviously it's an EU provision, but it's made part of domestic law by the European Communities Act. The fact the state has misunderstood it provides no reason why the state shouldn't be liable.
This could perhaps be, this is not contrasted just for the purpose of illustration with the case of Bodemere in 2011, where there was a conviction on the basis of a regulation from the EU, which subsequently it was discovered was irregular. Right. So the conviction had been based on legislation which was not in force. But nonetheless, the Court of Appeal Criminal Division upheld the conviction because they had jurisdiction, I think, as I recall, to say whether or not it was a safe conviction, and they were able to say that it was. But it needed some special provision to enable them to, or doctrine.
There is also, of course, I mean, I don't off the top of my head know the case, but there is also, of course, complications when one's looking at convictions, because the Strasbourg Court has recognised that a breach, for example, of Article 6 doesn't necessarily make the detention unlawful as a breach of Article 5. And so one can see there that different issues would arise if, for example, someone were to argue that they'd been unlawfully detained. Mm-hmm. Here, of course, it's executive detention, and the executive detention has to comply with the law. The point Lord Hobhouse is making is it's no defence to say, well, I misunderstood the law if you're the executive.
That's right.
Lord Hope also, to some extent, dealt with this. If one goes back to memory stick page 2373, his concern, which we would submit is the same sort of concern as would arise in this case, by letter D, was that if the governor was to escape liability, that would reduce the protection. And that's the fundamental concern, and that's in my submission what the court should be very reluctant to do. If in some way a right to damages is reduced in a particular context, that reduces the protection that this fundamental common law principle provides for individuals. Turning to the third point that I indicated I will address, which is whether or not there is any difference in the nature of the illegality. Deal with that fairly quickly. As is, I don't think, in dispute, power to detain, relied on in this case, is that under the Immigration Act. The Immigration Act, I don't think we need to go to it, but I'll give the reference. It's Volume 2, Tab 10. The relevant provision is Schedule 2, Paragraph 16, and that's Memory Stick 1842. That's in broad terms, but it's of course subject to a number of limitations, one of which is the European Communities Act. Again, I don't think we need to go to it, but the reference is Section 2, which is at Volume 2, Tab 11, 1946, and that's Section 2. Section 2, reflecting the primacy of EU law, indicates essentially that officials such as the Secretary of State can't act in a manner that's incompatible with EU law. So if the Secretary of State essentially acts in a manner which is inconsistent with EU law, which is what will have happened in this case if we're right on issue 1, then the Secretary of State is acting unlawfully as a matter of domestic law. There is no difference between the situation that has arisen and the situation that would arise if the Secretary of State breached Hardial Sin. The power under the Immigration Act has been exceeded, essentially, because the power under the Immigration Act doesn't allow the Secretary of State to act in a manner inconsistent with EU law. And Lord Justice Sales appeared to accept that. Again, reference, I don't think we need to go to it, paragraph 139 of his judgment, Memory Stick, page 289. He recognised that essentially the Immigration Act could be taken to be qualified by EU law. So there is no fundamental difference in the nature of the illegality. And of course, in the particular context of detention, Lumber, again, so I will take court to tab 5, volume 1, memory stick page is 1528, paragraph 66. Lord Dyson, relying on Annis Minnick, rejected any argument that there were different types of illegality in this context. So there is, in our submission, no fundamental difference between the circumstances that arise in this case and the circumstances that arise in, for example, a Hardial Sin case. Fundamentally, the same principle arises, which is why my learned friend correctly concedes there would be domestic abuse imprisonment is established, essentially. Now, my fourth point is that both EU law and the European Court of Human Rights recognise the importance of respecting domestic law protecting fundamental rights. Can I go back to the Charter? Tab 14 of Volume 2, relevant memory stick page 1973, has at that page Article 52(4) of the Charter. That says, insofar as this charter recognises fundamental rights as they result from the constitutional traditions common to the member states, those rights should be interpreted in harmony with those traditions. Now, Article 5 of the ECHR plainly demonstrates the importance attached to liberty within Europe. Uniquely within the Convention, Article 5.5, as the Court will be aware, provides that states are obliged to have systems of compensation. Article 52.4 suggests that in that context, it is important to recognise and respect, essentially, domestic constitutional provisions. And we would submit the common law right to false imprisonment is the sort of thing that should be protected, essentially, and preserved. And so it would be surprising if EU law in some way restricted domestic false imprisonment, particularly when also the European Court of Human Rights has recognised the importance of domestic safeguards in this context. If one goes to the folder that was handed up yesterday, within that was the authority of Rutkowski in Poland, which was in the printed case, but unfortunately missed out of the bundles. Not sure which tab it is because I set up my own bundle. Second tab, I'm told. Thank you. If one goes to paragraph 174 of that judgment, which is page 44 within the report. Second paragraph, this is one of the paragraphs which the European Court of Human Rights sometimes has, which has a number of paragraphs within it. Paragraph 174 is, and it's the second paragraph, where the court recognises essentially the need to respect domestic systems for providing a remedy for breaches of fundamental rights. So both EU law and the ECHR recognise the importance. So it would be surprising in our submission if there were requirement and need for this court to narrow common law protection. In fact, in our submission, what the materials I've just taken the court to demonstrate is that at a European level, there's a recognition of the importance of protections such as the common law right to damages for false imprisonment. Fifth, more generally, but consistent with what I've just said, there is no authority, and certainly none's been pointed to, that suggests that EU law essentially imposes an obligation on states to limit remedies. Cases like Factor Tame and Frankovic essentially were decided in contexts where there was no domestic right, there was no domestic tort. In fact, those judgments also recognise the importance of domestic rules for compensation. If one goes first to Frankovic, which is in volume 1 of the authorities, tab 3, page 1, memory stick 1393 is the relevant passage.
I beg your pardon, could you please give me the page again?
Sorry, within memory stick 1393.
Thank you.
Within the report, page 115. Paragraph 42 recognises the importance of rules of national law. Recognises at paragraph 43 the important principle of equivalence, that the remedies should be no less favourable. That principle of equivalence applies not just to availability of remedies, but to levels of damages. If one goes to the next tab, which is Factor Tame, memory stick 1494. One sees the principle of equivalence being applied, paragraph 83, one sees the principle of equivalence being applied in relation to the extent of reparation. So, in my submission, the way EU law operates in this area is EU law essentially sets a minimum. It recognises if there is no tort, there can be circumstances in which damages are payable. But it also recognises that domestic law can go further, and if domestic law goes further, then the principle of equivalence applies.
I wonder if you may not be overcomplicating this. Back to Tame, Frankovich, and the principles of effectiveness and equivalence are all to do with remedies for breaches of rights conferred by EU law.
Yes.
Here, we're concerned with a breach of a right conferred by domestic law.
Yes.
And the breach is simply a deprivation of liberty, and in the absence of lawful authority, damages are due under domestic law. It's not as simple as that.
Well, there was a little bit. I did think that yesterday, in light of the concession, I should just say, is there any real basis for disapplying those well-established principles? And
I have a feeling that I put that very question to Sir James yesterday.
I remember once you said about my advocacy that I have an engaging habit of engaging with everything. And as a matter of caution, I think, more than anything, it seemed to me that it was probably a good idea to put forward positive reasons why there shouldn't be a departure from those basic principles. But, my Lord, I would not disagree with what my Lord put to me.
Clearly there's an argument about whether the damages are substantial or nominal in the circumstances of this case. But I wonder whether the discussion of factor Tame and Frankovich isn't really a red herring.
Well, my Lord, I in some senses wouldn't disagree with that. As I say, I'm slightly concerned that what I've been guilty of is doing...
Well, I suppose you have to reply to the argument that's been made against you.
Yes, but my Lord, in my initial draft of my notes, I had made some sort of submission about how surprising it seemed to be in the Supreme Court arguing about the scope of false imprisonment when it was so well established.
I suppose I was prompted to intervene by your adding to the into the mix questions of effectiveness and equivalence, which are all to do with the adequacy of remedies for breaches of EU law.
Yes. Absolutely, my Lord. But in some senses, what my learned friend is seeking to do, which is why I've made reference to them, is he's seeking to sort of say, well, because the origin of this is EU law, this should be a departure from basic principles. And so I'm saying, effectively, well, there's a real problem with that, effectively, because that then does bring into play issues of equivalence. And you then end up back, essentially, with saying, why should there be any difference between, can there be compatibly, rather, with EU law, any difference between the approach to false imprisonment damages in that context and false imprisonment damages generally. So I think I'm hopefully just responding to the submission made rather than suggesting this is the correct approach, because our basic point is there is no reason for carving out a special approach, and as my learned friend accepts, the actual elements of false imprisonment are clearly established.
It's part of your answer to that part of the argument,
Yes.
that the court should fashion a new rule for these cases. Yes. But it's also part of your answer to the point about EU law, isn't it? Because it was argued that the claim was actually an EU law claim.
Yes. Yes, my lady. Can I just briefly then, given those comments, just deal with the last point very briefly, because I'll come back to it because I probably do, again, in response, need to deal with the submissions, essentially, about what the approach would be under EU damages. The learned friend's final point essentially is that as a matter of EU law, damages essentially reflect a balance struck. Now, there quite clearly are circumstances, and I accept that, factor tame is an example of that, where matters such as the difficulties in interpreting EU law are taken into account. But that's not necessarily a rigid approach. If one looks at, I'll just give the court the reference to it because I'll come back to it. If one looks at Dillenkopf as an example of that, Dillenkopf, which is volume 5, tab 56, page 3160, memory stick, and relevant paragraphs of paragraph 28. I'll come back to Dillenkopf when we look at the approach to EU law damages. Dillenkopf accepts essentially that there doesn't necessarily need to be any fault on the part of the state. If a state fails to take measures that it's required to take, that is per se serious enough for award of damages. So one doesn't see necessarily a balance struck. And that's important in this context because, of course, as I've already indicated, this is a context where EU law, as much as ECHR law, as much as the common law, recognises that fundamental rights are an issue. And that does raise a question as to whether, even if this is a question of EU law, and I'll come back to that, the sort of approach my learned friend advocates should apply. And our ultimate argument would be, in any event, if this is a matter of EU law, you get to the same point. You get to a point where there's an entitlement to damages, not least because of the importance of what's in issue. Can I deal very briefly with the two alternative ways that my learned friend puts the domestic law point about damages? First, my learned friend says, relying on Lord Justice Sales at paragraph 139, that principles of EU law, which include the right to damages, are directly enforceable. That, of course, is right, but I don't see how that assists the Secretary of State, because the fact that they are directly enforceable under Section 2 of the European Communities Act can't in any way mean that the European Communities Act narrows the entitlement to damages as a matter of domestic law. Finally, my learned friend says, essentially, Article 28 excludes, or says that it would be open to the court, rather, to find that Article 28 excludes the application of domestic law. That's paragraph 141 of Lord Justice Sales. Two brief responses to that. Firstly, Article 28 in our submission, on its face, plainly anticipates that it will be domestic law that is used essentially to detain people. It gives authority to detain in certain circumstances, but it clearly recognises the need for domestic law. It doesn't oblige the state to detain. Instead, it says, essentially, one needs domestic law, as is recognised in Article 2N, if one's going to detain someone. Secondly, in any event, even if that's wrong, even if effectively there is some freestanding power to detain under Article 28, it doesn't really assist the Secretary of State, because if the conditions of Article 28 aren't met, one comes back to the basic point that as a matter of domestic law, there is no authority to detain, and as a matter of domestic law, it then becomes false imprisonment. So even if I'm wrong, and Article 28, as I say, gives a freestanding right to detain, ultimately this remains false imprisonment as a matter of domestic law. So the third way in which my learned friend puts the case doesn't assist in my submission. So however one looks at it, there is no reason why this court should disapply the basic principle, the approach my Lord Reed indicated, which is that this is a matter of false imprisonment. As a result, domestic law applies. That then leads to the issue that the learned friend dealt with briefly, and which was rejected by Lord Justice Sales, which is whether or not, in fact, nominal damages are payable in this context. Justice Sales, of course, paragraph 148 of his judgment indicated that he was unimpressed with the Secretary of State's argument because it involved speculating about what would have happened under a different legal framework. Now, my learned friend essentially argues there's no speculation here because the 2017 regulations essentially indicate what the Secretary of State would have done. But in our submission, there is a degree of speculation because, of course, the 2017 regulations, as my learned friend correctly accepted, are not said to apply retrospectively, undoubtedly for good reason, because that would have caused its own set of problems. And so what the Secretary of State is essentially asking the court to do is consider how the Secretary of State would have acted under a legal framework that didn't exist at the relevant time, and that in our submission is problematic. The learned friend says, fairly, there is no authority that deals with that issue. Parker, to use that as, to look at that comment about Parker very briefly. Parker, of course, was a situation where, as I think my learned friend accepted, the police officers who actually carried out the arrest, or the police officer who carried out the arrest, didn't have the necessary statutory knowledge, but there were police officers who had the knowledge. So there wasn't the question about there needing to be some other legal framework in place. All essentially that went wrong, in one sense, in Parker, was that the officer who had the knowledge didn't communicate that to the officer who didn't have the knowledge, who carried out the arrest. Very different situation to the situation here. Because there wasn't, the legal framework was clear, and the legal framework would have potentially permitted the arrest. It was just a question of fact as to whether or not it would have been possible, essentially, for the officer who could have carried out the arrest to communicate their knowledge to the other officer.
Generally, it's not an answer to a claim for damages to say, well, I could have done it differently. If I'd known I was going to be liable, I could have performed this particular act in a different way.
Well, absolutely. But of course, the Secretary of State needs to go further here. In fact, the Secretary of State doesn't need to merely say, I needed to perform the act in a different way. The Secretary of State needs to say, essentially, I would have brought into place a different legal framework, whether that be legislation or a different policy. It doesn't really matter for these purposes. And that, and if one thinks about the cases that have been decided, think about Lumba. The Secretary of State's basic position in Lumba was, there's nothing objectionable in my secret policy. Now, had the Secretary of State's arguments in this case been correct, it would have presumably been open to the court to say, well, of course, the Secretary of State could have published that policy, and the detention would have then taken place under that policy. But that's not the approach the court took. The court clearly looked at whether detention was authorised under the published policy, the policy that was actually a lawful policy. So it didn't look at some hypothetical policy that could have been adopted, and perhaps would have been adopted had the Secretary of State understood the objection to not publishing to secret policies.
I wonder whether you're right to limit Lumba to that fact that there were, although not applied, lawful policies then in existence. Don't you think that Lord Dyson at paragraph 95 and Lord Hope at paragraph 176 expressed themselves more widely than that, Mr. Southey?
Well, no, in my submission. No in my submission, because the ultimate question that Lord Dyson indicated he'd answered, if one looks at paragraph 169 rather, is whether or not detention had the Secretary of State applied her published policy.
I think I was asking you about paragraph 95.
Sorry, my lord, yes. Well,
Have you got the bit at the very bottom?
yes.
If the power to detain had been exercised by the application of lawful policies, and on the assumption Hardile Singh, no problem about that, only nominal. And then I think I asked you about Lord Hope at 176, fourth line, an award on ordinary compensatory principles is, of course, out of the question. Plain that the appellants wouldn't have had any prospect of being released from detention if the Secretary of State had acted lawfully. What do you say about that?
Well, my point was, what I think my Lord was putting to me essentially, and can I paraphrase the question to make sure I've understood it? What I think my Lord was putting to me essentially was, don't those passages suggest that effectively if the Secretary of State had adopted some other policy that was a lawful policy, the question being asked essentially by the court is, would detention have taken place in those circumstances, and would it have been lawful in those circumstances? And that's why
I wasn't asking you about liability, I was asking you about more than nominal damages.
Sorry, absolutely, I accept it was in relation to the damages, but my Lord, what I was suggesting was that the question essentially in that context, I recognise that was about damages, the question in that context was, I think what my Lord was suggesting, the question set by the court in that context was essentially, would there have been detention if some other policy had been adopted, some other lawful policy had been adopted? And I was suggesting, if one goes to paragraph 169 in particular, which is looking at damages, by letter D, the assessment is against the actual published policy, not some hypothetical policy that could have been adopted that might have been lawful. My Lord, that's why I was going to 169, is because that, in my submission, is the clearest statement of what the court actually did, and that was to assess the nominal damages against the actual lawful policy that was in place, not some hypothetical policy, not, for example, a published version of the unpublished policy. I mean, if you could have assessed it against some hypothetical policy, you could have assessed it against a published version of the unpublished policy, but that's not, in my submission, what happens at paragraph 169.
Yeah.
Well, that's not the way that Sir Brian analysed Lumber, is it? In the Parker case.
Well,
Paragraph 104 on 1713. Having looked at Lumber in great detail, he says, the test, therefore, is not what would in fact have happened had P.C. Coutts not arrested Mr. Parker, but what would have happened had it been appreciated what the law required. Was that wrong?
Well, my Lord, the difficulty with that is it doesn't deal with the specific issues my learned friend accepts of how one deals with a situation where the legal framework that applied at that time, including things such as policy, was not effectively adequate to permit detention. And what the Secretary of State needed to do was essentially change the legal framework, because that simply didn't arise in Parker.
Well, the causation test required for any assessment of whether nominal should become substantial will always throw up a different factual inquiry.
But, my Lord, it's not just... my point, the reason I drew the distinction that I drew is it's not just there's a different set of facts. There are principled objections in my submission. All I'm indicating at the moment is that where the court has had to look at policy, it has done so, and I'll come back to a second authority that demonstrates this, on the basis not of some hypothetical policy, which, if my learned friend's arguments are correct, it could do. It has done so on the basis of the actual policy. Now, in my submission as well, there are good reasons why there is a different, that it would be contrary to principle for the court to be able to speculate essentially as to what would have happened, what would have happened had the Secretary of State appreciated that their current policy was unlawful. I'll come on to what those principled objections are in a moment. But the critical point is, as I say, in looking at Parker, Parker doesn't assist because there is that, in my submission, principled difference. It's not just facts are different. There is a principled difference between the situation where there is quite clearly an adequate legal and policy framework to permit detention, and a situation where the legal and policy framework isn't adequate to permit detention. And Parker is merely dealing with the situation where there was a legal and policy framework that in fact permitted detention. problem was the officers in the case didn't actually have the relevant knowledge.
I mean, otherwise, in a reductio ad absurdum would be ministers detaining people on their own say-so, and in answer to claims for unlawful imprisonment, saying, well, if we had gone to Parliament and sought the power, Parliament would have given it to us and we would have locked them up anyway.
Well, exactly, my Lord. That's one of the points. One of my four principal objections is, where does one draw the line? Where does one draw the line? And my learned friend may scoff slightly at that, but it is a principled objective. If one has to change the legal framework, where does one draw the line?
Well, in this case, it's not that different, because the argument is that if we'd appreciated the problem, we would have gone to Parliament, we would have laid before Parliament a statutory instrument for its approval.
Absolutely. One can see factually that it's not perhaps as extreme as the example, it isn't as extreme as the example my Lord gave. But the principle still is, the principal problem still is, how does one know what Parliament's reaction would have been at that particular time? One's speculating to some extent, because, and one is potentially also essentially saying to a detaining authority, you can effectively escape liability by saying we could have introduced different legislation. The principle remains the same. Can I just give one other example before I go on to my four principled objections to the approach the Secretary of State adopts? Just really in passing, volume 5 of the authorities, tab 48, is the case of VC, predates Parker, which is where the Court of Appeal addressed the approach to nominal damages in an immigration. Sorry, my lady, memory stick 2920.
292.
Is the relevant passage, which is where the Court of Appeal addressed the approach to nominal damages. Gave effectively guidance which, in my experience, is now applied routinely, essentially, in an immigration context. And the critical point again is that the Court, unsurprisingly, at paragraph 62, A and B, essentially establishes a would and could test. It makes it clear that the would and could test applies in this context. But in the context of could, refers to satisfactorily managed, that is a reference, quite clearly a reference, to the actual policy that was in force at the relevant time, paragraph 18, not to some hypothetical policy that could have been adopted by the Secretary of State, which perhaps would have been more generous. So again, one sees the Court of Appeal, admittedly, in circumstances where this issue perhaps hadn't directly arisen, circumstances where this argument wasn't before it, applying not some hypothetical policy, which was as favourable as it could have been to the Secretary of State, but applying the actual policy. Now, in my submission, there are four principled objections to the approach, essentially, that my learned friend argues for. Firstly, at the heart of Al-Chodor, and the Court's probably pleased to take the Court back to it, but I'll just refer to paragraphs 38 and 42, which are memory stick 1687, tab 7. The Court of Justice, emphasised essentially that at the very least, what it understood Dublin 3 as requiring was a law that was foreseeable and that ensured that the discretion to detain was exercised in accordance with predetermined limits. Obviously, there's an argument about what that means, but that's the critical point, is that the European Court was saying that in some way there needs to be foreseeability. if essentially damages can be assessed against some legal framework that isn't in force at the particular time of detention, but comes into force later, that isn't firstly predetermined, but it's also not foreseeable. My learned friend says, look at the 2017 regulations. They show what we would have done if we'd appreciated our legal obligations. How could someone who was detained before those 2017 regulations, which is what we're looking at here, know? That would be how liability for damages would be assessed. It would have been entirely unforeseeable. If you'd gone to a lawyer at that time and said, I believe I'm wrongly imprisoned, I believe that there has been the correct application of Dublin, how could the lawyer have said, well, you may be falsely imprisoned, but your entitlement to damages will be reduced because of this legal framework that in fact will be introduced sometime in the future.
Where does knowledge of how much damages I'm going to get come into it?
Well, it's the legal framework, and we would say damages are part of that legal framework. The legal framework has to be foreseeable.
Well, the considerations which will be taken into account in deciding whether I should be detained must be foreseeable. But I hadn't actually collected that quantum had to be foreseeable.
What has to be foreseeable in my submission under the Strasbourg case law is effectively the law, slightly paraphrasing, but I would submit not inaccurately, is the law that governs detention. And the law that governs detention must include, essentially, potentially the remedies for false imprisonment. Linked to the point I've just made, my learned friend recognises, as he did in his submissions, that were the regulations to have been applied, as in principle they could have been, the 2017 regulations retrospectively, that would have raised its own set of issues correctly, because there are all sorts of problems. For example, if you try to enact, if a state tries to enact legislation that changes rights that are already subject to litigation. Of course, Parliament, as I say, for understandable reasons, didn't decide to make the 2017 regulations retrospective. But in our submission, if one says essentially entitlement to damages can be assessed against the 2017 regulations, one is to a large extent making them retrospective, because one's giving the Secretary of State protection of those 2017 regulations.
You're giving it a retrospective force.
Giving retrospective force, yes. The third point that we'd make really goes back to the point Lord Reid put to me a moment ago, which is essentially the logic of the Secretary of State's argument, which I'd accept, is essentially the executive could detain someone completely arbitrarily and then introduce a piece of primary legislation saying what we did was lawful, essentially, or saying...
Well, that wasn't quite the point I was putting to you. What I had in mind was that it's one thing to say, as Sir Brian could have said on the facts of Parker, or Lord Hope could have said on the facts of Lumber, that lawful authority was available to me if I had appreciated that I required it.
Yes.
And I made an honest mistake and didn't get it. it's something else to say that the law might have been changed so as to enable me to obtain lawful authority.
Yes, sorry, I was perhaps going too far, but taking that point, my learned friend, the point I was going to make is that my learned friend, his reactions when that was put, sought to suggest there was some sort of distinction between the situation here, where, in one sense, perhaps it's secondary legislation, it's fairly predictable what would have occurred, and the situation that my lord was putting. But my point is here is if one says, as a matter of principle, it is possible for the Secretary of State to avoid liability for damages on the basis of a piece of legislation that wasn't enacted at the relevant time, but was enacted afterwards, once illegality was drawn, where does one draw the line? How does one decide, essentially, that principle can be applied without then opening up extreme examples, essentially, without opening up the possibility of defeating damages claims in extreme examples?
Taken to its extreme, it would subvert the rule of law.
It would, and it would make false imprisonment meaningless, because the Secretary of State could always introduce a new piece of legislation saying, in the circumstances of this case, in fact, we'll now authorise a power of detention. And the fourth and final point I'd make is that Lord Dyson's basic approach to damages, if one remembers, paragraph 93 of Lumber, memory stick 1534, was that someone should be put in the position they would have been put in had no tort been committed. Now, effectively to say, well, you could have been detained if some hypothetical legal framework had been in place, which wasn't in place, it's not to put one in the position you would have been in had no tort been committed, because one doesn't have the general protection of that new law. One didn't, if one thinks about the position of these appellants, one won't have had the protection of the new regulations, what they say about Article 28, what they require of the decision maker. All one will have had, essentially, is, all that will occur is that one will have been denied damages. And the correct analysis is, applying that approach, looking at how one would have been treated had there been no tort. The correct analysis is, at the material time, there was no legal authority for your detention because the Secretary of State didn't have a relevant instrument in place, and as a result, you wouldn't have been detained. That's the only way. That's ultimately how one is. That's how one is put in the position one would have been had there been no tort. It needs to be recognised, essentially, there was no authority for your detention. So those four principled reasons in my submission demonstrate, essentially, that my learned friend's submissions go too far. While, as in Parker, one can look at a situation where the legal framework existed, but factually there was an error, and see what would have happened had that error not been made. One can't go as far as looking at what would have happened had it been recognised there wasn't a proper legal framework in place, and look at then whether or not a different framework would have been enacted, because as a matter of principle, that goes too far.
Are we making too much of a meal of the change of the relevant considerations from Chapter 55 into the regulations?
Well, I'm not quite sure what I understand.
Well, you say that's all that, if you need a new law, for goodness sake, then you can't use the Lumber causation criteria, because it's a different ballgame. And I was simply wondering whether it's all that big a change that the considerations set out in Chapter 55 should have been shifted, if that was what was required, from policy into the regulations.
Well, the critical point is it's not so much the the extent of the change, in my submission, that can't be a relevant factor when looking at principle. The critical issue, which is what I was trying to highlight, was that at the material time, the framework didn't exist. There needed to be a change, and talk about how big or small that change was, but it needed to be made because there wasn't the necessary framework in place. And so what my learned friend has to do, and does do, is my learned friend has to argue, essentially, one should assess damages not against the actual framework applied at that time, against some hypothetical framework that as I say, didn't exist at that time. And whether or not that framework involved a big change or a little change, it still, as a matter of principle, means that damages are being assessed against a legal framework that wasn't in force at the material time. And that's the critical thing. It doesn't matter in our submission.
Okay, thank you.
Just sorry, one final point on that, and one of the reasons for that goes back to one of the points I just made. If one starts looking at sort of degree of change, how does one decide how big a change is needed before damages essentially become an entitlement?
Another aspect of it that one should perhaps bear in mind is that in order to make the regulation, it isn't simply a ministerial act. There would have to be parliamentary approval, and whether the court could make a finding as to whether Parliament would have approved the regulation or not may not be a decisionable issue.
Yes, absolutely, my Lord. And of course, in a standard false imprisonment case, in a normal, perhaps lumbar case, one quite often sees evidence from the Secretary of State saying, essentially, had I realised this, this is what I would have done. Perfectly acceptable because it's looking at the facts. What does one do? I mean, one see all sorts of principled problems with this. Could the Secretary of State file a piece of evidence saying, essentially, had I realised this was my legal obligations, I would have presented this to Parliament, and I believe Parliament would have enacted it. Now, that's a very, very troubling sort of approach, evidentially, and one in my submission the court shouldn't really involve.
In fact, on this case, I don't wish to in any way undervalue that point, but the regulations appear to come into force before Parliament has a sight of the regulations.
But of course, Parliament, even whether it's positive or negative regulation, Parliament still has so one's still in a position, even if it is positive or negative regulation, one's still in the position that the Secretary of State has to be in a position to say, Parliament wouldn't have set these aside.
Absolutely.
Can I deal briefly, given the time, with EU law? Because we do submit, in some senses, and this supports our argument, that there shouldn't be any different approach to common law damages in this context, that even if one were to apply EU law, even if one were to apply EU law, one would get the same conclusion. Now, my learned friend emphasises factor-tame. Can I just take the court to factor-tame as a starting point? Factor-tame is at volume 1, tab 4, and I think the relevant memory stick page is 1489. Paragraph 45 sets out two policy considerations, essentially, that the court identified as potentially relevant to liability. And the second of those was whether or not, essentially, there was a wide discretion granted to member states. In the context of a wide discretion, the test was said to be the manifestly and grave test. Now, the court expressly recognised at paragraph 46 that the approach to damages, as I say, depended on the margin of discretion, because it noted in the second sentence of paragraph 46 that obligations to achieve a particular result may reduce the margin of discretion. Now that approach is reflected in Dillenkopf, which I made reference to in passing. If one goes to volume 5, tab 56, memory stick 3158, this was a case where essentially, as one sees at paragraph 17, where the issues are summarised, the German government, sorry, it's memory stick 316, I'm not sure if I said that, the German court had, or the German government rather, had failed to transpose a directive because it said essentially that the time was inadequate. And the approach of the court, sees at paragraph 28, was to say one didn't need necessarily fault on the part of the government or negligence on the part of the government. Instead, in paragraph 29, the failure to take any measure to transpose a directive was in itself a sufficiently serious breach. So one sees in my submission, if you like, the recognition of the spectrum. At one end of the spectrum, there is a situation where the state has a broad discretion. Other end of the spectrum, there's a situation where the state has no real discretion, it has to do something. That's also reflected in Bern, which is the Court of Appeal Authority, which is volume 4, tab 37, 2656, memory stick. Paragraph 32, the court indicates that essentially there are three requirements for the payment of damages. One, direct effect, essentially. Two, sufficiently serious breach. And three, causal link, not the manifestly in grave test. Sorry, paragraph 32. Now, importantly, what the court then goes on to do at paragraph 39, having referred to Dillenkopf, indicated that there was little room for discretion, and that was a relevant factor in terms of damages. It did that and then went on separately to consider the clarity of the provision, because it distinguished Dillenkopf to some extent on the basis that the provision was less clear, perhaps, than the provision in Dillenkopf. That's important in this context, because ultimately, if you think about what was an issue in this case, the requirement to have a law, as in Article 2N, I won't obviously argue about what that means, is clear. There's no discretion. One has to have a legal provision, whatever that legal provision is. The discretion is in terms of what criteria might be identified as relevant to risk. But the basic requirement, which is what's an issue in this case, is not a discretionary requirement. Now, there may be arguments about how clear that requirement was, but it's not a discretionary requirement. And the approach of the European Court is to distinguish between those cases where there is a discretionary requirement and those cases where there isn't. So the starting point as a matter of domestic law in my submission is quite clear. One looks at the fact this isn't discretionary. Secondly, in terms of other factors, the ultimate conclusion reached in Bern, paragraph 45, was that Frankovic essentially isn't a hard-edged case. It needs to look at factors summarised by the European Court in Evans. for everyone's note, the reference to the court's note, the reference to Evans is a reference to paragraph 86 of Evans, as I understand it, which is at memory stick 2653, paragraph 20. One back to the European Court in particular, sorry, not the Court of European Court, the Court of Appeal in particular, highlighted in paragraph 45, was the serious consequences of the breach. Now, here, one looks at this purely as an EU point. The consequences of the breach here were illegal imprisonment, false imprisonment of a vulnerable individual, an asylum seeker. As I've already indicated, EU law recognises ECHR, respects ECHR standards, and there's a right to damages in that context. See Article 5.5. And so one has, in my submission, a situation where the nature of the breach carries very significant weight. The breach was one in the context of liberty. That's a second factor that weighs highly. When one takes those two factors together, in my submission, applying the sort of soft-edged approach adopted in Byrne, in my submission, this is a sufficiently serious breach and one that would, as a matter of EU law, sound in damages, assuming, as I say, there's more than nominal loss. I'm not suggesting that EU law would go beyond the approach of domestic law, but I am suggesting EU law would equate to domestic law, even ignoring the principle of equivalence. And of course, if EU law gives a right to damages, as I've already drawn attention to, the principle of equivalence would suggest that the damages should be the same as false imprisonment, essentially. So, in our submission, fundamentally, to the extent my learned friend says, depart from common law principles on the basis that EU law would effectively provide less entitlement, in my submission, that's quite an unsafe basis, because on a proper analysis, we would argue EU law would result in the same award of damages, essentially, because of the two factors I've identified. Finally, can I just say a little about issue 3, which is remedy, in relation to the two appellants I represent, Mr. Abdul Qadir and Mr. Mohammed. In their case, at first instance, Mr. Justice Irwin, as he then was, essentially decided the case on the basis that there was no conflict between domestic law and Article 28. The grounds of appeal, just give the court the reference to them, are Appendix 2, page 442, ground 6, expressly challenged that finding and highlighted, for example, the fact that on the decision-making, no account had been taken of obligations in Article 28, such as the need to consider less coercive methods of securing attendance. And that's a provision of Article 28.2 that hasn't, for understandable reasons, received a lot of attention, but it's there. The grant of permission, see Appendix 2, memory stick, page 514, expressly addressed and granted permission in relation to ground 6. And so we would submit remittal to the Court of Appeal would be required if we lose on issue 1 in relation to the two appellants I represent, because there is still a freestanding issue, a substantive issue about whether or not their detention essentially complied with Article 28. I just turn round to see those behind me and just check there's nothing else. That concludes, unless the court has anything they wish to ask me, my submissions. I know my learned friend has just a couple of things he would wish to say in addition.
We're still on track, and I promised you non-duplication. There will be no duplication, but I do want to come back to this point about the rule of law and lumber and nominal damages. I do want to show you some more passages. You don't interpose a hypothetical lawful instrument of relevant law when you apply the lumber counterfactual. It is a counterfactual, not a counterlegal. And Sir Brian Levison at page 1713 is talking about a counterfactual as against what the relevant law required. And so was Lord Hope at page 1556. So what is the police officers acting lawfully against their legal framework is the detainer acting against the lawful legal framework. And this principle must be the same whether or not you happen to have the same public authority who would be the rule maker, whether or not with the House of Commons or Parliament, or whether they're different. So in the police case, it wouldn't be for the police to change the legal framework. And in some cases about policies or rules, it may or may not be. So that's all we get from Levison and Lord Hope. Lord Dyson at paragraph 95 was talking in the plural about lawful policies, but he must have been talking about the policies that were lawful, and they were lawful because they'd been published, and the law required a published policy. That's at page 1534. But he makes it very clear, because that later paragraph 169, he uses the word because, and he's giving his reasons as to why it's nominal damages. And it's nominal damages in the conclusions of Lord Dyson, as you've seen, at 169, because if the Secretary of State had acted lawfully and applied her published policy, there's your lawful policies, it's inevitable that the appellants would have been detained. Now that's the focused reasoning of Lord Dyson, explains what he meant earlier when he was talking about acting in accordance with lawful policies at 95. And that's the bit, must have been the bit that the others were agreeing with. But just have a look at my Lady Hale at 1565, please. 1565. The third question, says my lady at 1565, paragraph 208, is whether it makes any difference that in these particular cases, if the officials had been operating the published policy, they could and would have authorised the detention. And at the end of that paragraph, you agree with Lord Dyson, no doubt having read his conclusions and his focused paragraph 169. Lord Kerr is another example at 1577, because Lord Kerr at 1577, paragraph 253, is positing, again, the counterfactual, letter G on 1577, they would have been lawfully detained had the correct procedures been followed. The procedures were published, the published policies. And all of this, remember, in the context of the rule of law. That's what Lord Dyson had described at page 1521, paragraph 34. 1521, paragraph 34. The whole point is about published policies being required for lawfulness and acting in accordance with them is because that's what the rule of law requires, and it must be prescriptive and it must be prospective. And here, of course, we have our own equivalent applicable but heightened standards. But just finally, two passages to reinforce this in a non-duplicative way, I hope. The court in Lumber was very clear that there could have been an alternative lawful policy if published, and it would have been more exacting. And Lord Dyson explains that 1525. 1525, subject to the points he makes at the end of 53, Singh observed in each case considered individually, you could have a policy of a presumption of detention. And that's the whole issue that Lord Dyson is discussing. presumption of detention starts at 1522 at paragraph 40. And so you can, paragraph 54, have a policy setting out presumption of detention that you'll normally follow to detain foreign national prisoners, providing you meet those two criteria. Now, bearing in mind, and my Lady Hale, this is the final reference at 1564, paragraph 204, 1564, paragraph 204, the court was well aware in Lumber that the Secretary of State's intention was to go as far as possible, to have as expansive a detention policy as possible. Just have a look at the end of 204 on 1564. Ministers wanted a near blanket ban on release. The law requires some flexibility. So you can see the way it would have gone. Don't test it against the published lawful policy. That's not the right question. Posit that the policy maker to apply the standards of the rule of law had, albeit we're doing it retrospectively in rewriting history, published the lawful policy that would have reflected what we know was the policy appetite of the executive. So we submit, as a matter of authority, you can see that the Lumber principle does not involve that exercise, and it does not involve that exercise for good constitutional rule of law reasons. It would mean detain under a policy that is secret. Don't worry, no one will ever get legal aid. They'll never take me to court because there's no damages. The damages are nominal because the court just says, well, posit you would have done what you should have done, i.e. publish the policy that you had kept secret. It is a big change from deficient in rule of law standards to meeting the standards that are required for prescription under the rule of law, or from secret policy to published policy. Or in this case, or for that matter in Choddle, from having a framework that is not compatible, so they get released, to a framework that is compatible. And finally, it's no answer, and I know this wasn't being suggested, that it comes into force and is then laid before Parliament. The Statutory Instruments Act 1946 deals with that in section 2. It's in the bundles. I'll give you a reference if you want. It's also in our printed case. If it's urgent, a statutory instrument can come into force, but that doesn't mean you're not having the safeguard of laying before Parliament. And in fact, when this one was laid before Parliament, it was explained there'd been a breach of the convention, but it's urgent and it's now being laid. And so there's really no point of principle we would submit in that distinction. And I'm just asked to say and to remind the court, we would need a remittal on the causation issue, were it to be relevant and were it to arise. We've never accepted, and no court's ever decided that we would lawfully have been detained under any counter legal analysis, even if one were available in principle to the Secretary of State. Thank you for allowing me just to add those submissions.
And I think we have so many juniors in this case that it would not be sensible for me to ask each of them in turn whether they wish to follow their two leaders, if they'll forgive me. Mr. Fordham, I think somebody is trying to tug your gown.
I'm being asked to check that I've covered issue 3, but I said I would sit tight, and I don't think I need to add anything to what I've said. You know our position on why it would need to be remitted.
Just to start with the small factual question that my Lord Wilson asked. The position, as I understand it, having made some inquiries, and this is derived in part from a Freedom of Information Act request issued to the government by a barrister, which I confess I'd never seen before, but I'm sure it happens regularly. But as a result of that, it's clear that the regulations were drafted after the Advocate General's opinion and before the judgment of the CJU. I don't know precisely when the draft judgment, if it came out in draft, was in the hands of the government.
That would have been very wise, given what the Advocate General had said about practice in other states.
Well, that was the point I was going to make. I was also going to make the point that in the Advocate General's opinion, if the CJU had gone with it, his opinion was to the effect that you did need something legislative. You needed legislation. And if that had been adhered to by the court, then there was only one way of doing it. As we know, and no one seriously questioned this, as I understand it in the oral submissions, at least before this court, that isn't what the CJU did. The CJU did not say you need legislation definitely. See, for example, for the analysis of that, Lord Justice Sales, para 96 to 97, which I showed you earlier, about that distinction between the Advocate General and the CJU's approach.
But the explanatory note does refer actually to the judgment of the court.
Yes.
So that must have been drafted in a hurry.
It must have been drafted in a
just
hurry.
Before
exactly
the day
so.
it was laid.
Exactly so. But I think in answer to the Freedom of Information Act request, the answer was that the regulations had been drafted,
yes.
I think that was the stuff of it, between the 13th of February and the 15th of March.
Thank you.
2017.
Thank you.
It may be just appropriate to mention that there appear to be decisions of the Cour de Cassation and the Conseil d'État taking the view that you need legislation, following Chodor.
Well, my lady, I'm afraid I'm not aware of those decisions, but we have our domestic analysis, and no one seems to be querying that, at least. Whether that is just the way they've gone after it, I'm not sure, and I'm not sure what their legislative system would look like, or their alternatives. So, can I go back, if I may, to the question of whether or not there is in fact a breach of EU law? My learned friend Mr. Fordham asserted that there was no real correlation between our provisions in Dublin 3 and the provisions in the recast reception directive. And he sought to make that submission because he recognised the difficulties that would otherwise exist created by that correlation between the references to national law in the recast reception directive and the reference to law as a single word in the definition section in Dublin 3, Article 2N. And he said, well, there's no correlation because the recast reception directive is a directive. And of course it is a directive, but that provides no answer to the points that we made. The recast reception directive, as you will recall, refers as one of the permissible bases of detention to the regulation itself. In other words, to Dublin 3 itself. You'll remember that paragraph 8F in the recast reception directive. I don't go back to it, referring specifically back to Article 28, or I say back sideways to Article 28 of the Dublin 3 regulation made on the same day. And it then provides, as you'll recall in the recast reception directive, in the tail piece, after setting out the grounds of detention, it then provides that the grounds of detention shall be laid down in national law. That was the tail piece. So it's no answer to say, well, it's a directive, and so it would obviously refer to national law because of that direct correlation. Moreover, the regulation itself, in other words, Dublin 3, provides for member states to exercise discretion as to certain elements, exactly as directives do, so there has to be some form of domestic reaction. Here, one of the discretionary elements is in relation to the inclusion in domestic law by member states of the, quote, objective criteria defined by law. In other words, Article 2N. And it applies, moreover, that regulation, the provisions of the directive, the recast reception directive, directly by incorporating them in Article 28, sub 4, which just simply refers across to a series of articles relating to the conditions of detention and guarantees and so on. It simply refers straight across to articles in the recast reception directive, and they include Article 9 of the recast reception directive, which had all of those references to defined by law laid down in law. So in my submission, the national law point that I made in opening, and its contrast with law and effectively meaning the same thing, cannot simply be explained away by referring to the recast reception directive as a directive. That provides no answer whatever to the points that were made in opening. Nor was there even an attempt to answer the bull purposive or teleological point, where is the coherence in having fundamentally different required legal forms or ingredients for different grounds of detention? Why would you do that? Why would you create two disparate systems, one under the directive where you have all those other grounds that can apply outside transfer cases? Why would you have a fundamentally different legal setup governing those? So again, national law in the recast reception directive and law in Article 2N of the Dublin III regulation mean effectively the same thing. And the true position that we submit is that the legislative scheme, the EU legislative scheme, needs to be interpreted as such, as a composite legislative scheme. And for that reason, and for the reasons I gave in opening, law and national law are effectively saying the same thing. And of course, the significance of that point is that it takes one well away from loi and droit and all of that, or even the quality of law. It's simply a reference in Article 2N to national law. ECHR principles, if I can turn on to that, and what was Chodor doing in relation to ECHR principles. My learned friend Mr. Fordham said that the CJAU was deliberately going further than the ECHR, and specifically, as you recall, if you have Chodor open, if you would, it's bundle 1, tab 7. And the relevant parts for present purposes, for the purpose of this point, are they going deliberately further than the ECHR, is paragraph 40, and you'll remember that I took you to paragraph 40 and then 38 and 39, which were setting out the ECHR position, and then para 40 that follows from the foregoing. And my learned friend's argument appeared to be that foregoing includes not merely 38 and 39, which directly precede 40, but can include other paragraphs earlier in the judgment. But it is clear, we submit, that the reference to the foregoing in 40 is indeed to 38 and 39, especially because if you read those paragraphs together, you will see that the summary of the principles in paragraph 40 are all reflective and directly reflective of the ECHR principles they have just referred to. And they then go on and apply those safeguards or those principles in the subsequent paragraphs. There's nothing in the earlier paragraphs to indicate any indication to go beyond the principles identified in the ECHR. Mr. Fordham said that those earlier paragraphs were referring to a higher level of protection, implying a higher level of protection than the ECHR. And that, we respectfully submit, is simply wrong when you read, for example, paragraphs 33, 34 and 35 together. The purport of those paragraphs, which were the ones that he referred to, is of course to refer to a high level of protection afforded to applicants covered by Dublin III, because it's a detention context. One sees that from the first line of paragraph 34. But that is not surprising. It doesn't indicate that they were intending to go beyond the ECHR. A high level of protection for those in detention is equally provided in Article 5 of the ECHR. So there's nothing in that. My lady, I'm sorry.
I'm sorry, I didn't mean to interrupt. I just thought, is it relevant to note what the Advocate General said about that? 59 to 69, 69 to 70.
You may have, do you have in mind 80 to 80?
Where he says that there was a discussion at the time and that it was intended to have a higher standard. I just recollected.
Find the bit. So I'm just trying to find the relevant part. Is it 41? Does my lady have in mind 43?
Yes, and going on from there.
43 to 45?
Yes.
My lady, that is true, and it's another example, it might be thought, of the Advocate General setting that out and the European Court not going there. Because when the European Court come to deal with it, they deal with it much more gently, if I can put it that way, in the paragraphs that we've just seen, 38, 39 and 40.
Thank you. Thank you.
So that's what we say. We positively acknowledge that the Advocate General was seeking to adumbrate that principle. But the European Court's reasoning is in 38, 39 and 40. So just to go back to the Court's judgment, if I may, I think the suggestion of greater guarantees was taken by my learned friend Mr. Fordham from paragraph 35 of the Court's judgment. But 35 of the Court's judgment does not involve a comparison between EU law and ECHR law. It involves a comparison between Dublin III and what had gone before. And of course it's right that the higher protections were provided in Dublin III than had gone before. But it's an apples and pears comparison, therefore. True it is, as we all know, that in the Charter there is, if you will, a reservation of EU law right to go further in Article 52, sub 3 of the Charter, which provides for the possibility of more extensive protection. But it's equally clear as a principle under the Charter that when the rights in question are designed to give effect to ECHR rights, they take their scope, as it were, at the very least prima facie and absent clear indication to the contrary, from the ECHR rights they are intended to replicate. And one has had that principle set out in all sorts of contexts and different cases. But here, Article 6 of the Charter and Article 5 of the ECHR are materially the same. There is no suggestion that there's another right in the Charter that goes beyond the right to liberty guaranteed in the ECHR and the requirement that detention should be in accordance with law. And so we do respectfully submit that there is no indication in the case law. The Advocate General's opinion provides a counterpoint to the Luxembourg Court's reasoning. And just to come to the point that my Lord Kitchen was interested in, the question whether the check system would necessarily have passed muster under the ECHR. Well, it might have done, or it might not. It's not entirely clear, I have to say, whether it would have done, even under ECHR, because all of the principles that the ECHR sets out are to be applied in the particular context that they are considering, and detention is regarded as a pretty serious context by the Strasbourg Court just as much as the Luxembourg Court. So it isn't entirely clear, or it's far from clear, we submit, that the check system would have passed muster under that, under the ECHR. And again, one goes back to it. It's fair to point out that the Advocate General evidently regarded that as being the position, passages my learned friend took you to this morning, but the court doesn't go there. So it's the same point.
Thank you.
The features of the check system and whether they are properly to be compared to ours, again, I went through that in some detail in opening. The counterpoint in Al-Chodor of consistent administrative practice confirmed by case law is, we submit, a very long way away indeed from Chapter 55 and the effectively binding requirements of public law, a point I'm going to major on in this reply, if I may. And if you still have the Chodor judgment open, can I just invite you to note paragraph 11 of the court's judgment, which sets out the relevant Czech law. And you will see, I think I said in opening, it was cast in mandatory terms. and I also put it, I hope not disrespectfully, to the Czech system, that looked like the very thing that Article 28.1 was designed to prevent. It's a duty to detain in circumstances in which you're thinking about transferring. So it was a problematic system of law for all the reasons, and I gave you the references into our case 5.7 to 5.9, summarising the fragmentary and difficult nature of all of that. But the core submission that my learned friend Mr. Fordham majored on was that public law, under our system, to come more directly to the policy that we have and what its wraparound of public law gives one, that our system is not adequate for two slightly different reasons, and I'm going to break them out because it's important to treat them and approach them separately. The first is because he says that the tailpiece to the key public law principle, unless there's good reason to depart, means that the law can't effectively be binding or satisfactory from an EU perspective. And the second of them is because he says that our list of questions in the policy are not exhaustive. Take the first one first, unless good reason to depart, which is, as he rightly pointed out, the consistent tailpiece when this principle of public law is described in all of the cases, including the passages in Lumba, which he took you to. So we've got no disagreement that that's the basic principle of public law that is in play. But it is very, very important in the context of this policy to consider what that means in relation to our particular context. The basic legal rule, as we're all agreed, is follow the policy. That's a binding public law principle subject to the rider. And that means here that the person concerned, the decision maker, needs to consider the criteria set out, or the questions set out, in 55.3.1 when considering the individual case and when considering whether there's a risk of absconding. The basic legal rule is you must apply that policy by considering those questions. So you are not following the policy, and if you're thinking about what would trigger the unless good reason to depart, you're not following the policy if you fail to consider one or more of those questions or those criteria. And once one understands that, the next question is, well, what would be a good reason for not even asking the question in an individual case? And it is impossible to see what could be a good reason for not doing so. The answer to the question might not be relevant on the individual case, but you'd still need to consider that. You'd still need to address the criteria to ask the question. So public law would require those questions to be considered without exception. Put another way, there is no scope for good reason not to follow the policy to operate in this situation. And no one has advanced any realistic, or indeed any scenario, in which there might be a good reason not to follow, by which I mean don't even ask the question, set out in 5.3.1. And binding is not, therefore, we submit, undermined. That tailpiece simply doesn't have any public law scope to operate, because the questions are simply addressing the decision maker's mind to questions that they have to ask. And it's impossible to see how they could ever have a good reason for saying, well, there it is, there's a question that goes to the risk of absconding in the policy, and I just decide not to ask it. It's just simply, it's totally different from relevance, of course, to the answer given, but not to ask the question simply doesn't have any scope for operating. 2 points to note in relation to this part. The first is that Chapter 55 has been described as containing instructions. I know my Lord Wilson was interested in that, instructions versus guidance difference. And can I just give you the reference to that? It's in Kambadzi, MS 1636, para 51. And the second thing to note about the EIG, my learned friend Mr. Fordham went back to 55.3.2.5. Do you remember the bit headed risk of absconding? And he rightly pointed out that that was to do with the criminal side of things, criminal casework. But the significance of that paragraph, and the reason I drew it to your attention, was because, as I put it in opening, that paragraph replicates, to all intents and purposes, all of the questions that are relevant to risk of absconding that you see in 55.3.1.
But Mr. Fordham, who knows this whole book well, no doubt, as you do, but we don't because we've only got chapter 55, said quite firmly to me, chapter 55 is guidance, not instructions.
Well, we'll double check to see if we can reach an agreed position on that. I don't want that to be...
Well, we're going to assume he's right on that, unless you tell us that you disagree.
That's fine, all right. Well, I will double check the reference to para 51 in Cambazi to see which bit of 55 it relates to. So I'm perfectly happy to leave it on the basis of that assumption.
Okay.
That's the first bit of it. I don't want to distract from the main event, which is, does unless good reason to depart alter the binding nature in public law? And the base point is public law can't conceive of a decent reason for not even asking the question. The second issue is whether or not the criteria have to be exhaustive. And if that is a requirement of EU law through Chodel, in other words, that it has to be exhaustive, then you have the arguments and the points that Lord Justice Sales made at 117. And there's a proper argument that if EU law does require it to be exhaustive, it is to be treated as exhaustive. And I don't think on reflection there is such a logical difficulty of the kind that my Lord Reid was putting to me yesterday. You simply say, well, it's part of the EU law requirement that those questions should be the exclusive list. And so you approach them through the prism of EU law, and they are contained in that way. I think, with respect, that's what Lord Justice Sales was doing. Of course, that doesn't answer it if it's got to be legislative, but on there the logical issue might arise. But with this one, you just approach those questions as though they're exhaustive, if that's what Chodel required. But my submission is that it isn't what Chodel requires. Chodel does not require that there should be an exhaustive, prescriptive, predictive cage of the kind that Mr. Fordham would have you take from it. And there are, we submit, at least 6 reasons for that. First, none of the language in Chodel goes that far, requiring that degree of rigidity of legal structure. And I want for this purpose, because a lot of this was argued about and the subject of decision in the Omar case. So if you could take up bundle 5 and have it to hand, if you would. Tab 52 is Omar, and none of the language goes that far, requiring the degree of rigidity is the first point. And paragraph 41 in this judgment on electronic 3060 is of some interest in relation simply to that language point. He also suggested that Mr. Fordham, on this language point, that the words used in Chodel included the word certain. And I'm going to hand up, if I may, 2 documents, and the one I'm just about to refer to is at the back end of the little clip. Thank you. He said that the word certain indicated and supported this certain predetermined limits was the phrase, and he said, well, that supports rigid criteria. But there is a question, and there is a question which is whether or not the use of the word certain in the English language version of that judgment does indeed refer to sureness as a concept, as compared to some, or particular, or specified. There is that's the issue of interpretation. The only reason for giving you the single sheet at the end of this little clip, which has the Al-Chodel judgment, first sentence of para 42, is to show that at least some of the other judgments do not convey anything like that sense of certainty as in sureness. Some of them indeed leave out the word entirely, and are much more consistent, therefore, with this just being certain in the sense of specified or some. That's the first submission. No language in Al Chodor suggesting exhaustive. Second submission, Dublin 3 has left the formulation of the objective criteria to the discretion of the member states. You don't have to have in the member states all or substantially the same criteria, even though, if it was intended that there should be exhaustive criteria, that would be implied. That's the point made in the Omar judgment at paragraph 38, if you still have that page to hand. 3060. Third submission is that individual consideration applies both to detention, i.e., even if there is a risk of absconding, and it applies to the risk of absconding. And I think there was a question that my lady, the President, asked about whether or not that was actually so and whether the discretion wasn't confined to the detention element of it. My submission is that it's clear that it applies equally to the risk of absconding, and that is because, as you will have seen from the definition provision in Dublin 3, Article 2N, it refers to, quote, reasons in an individual case. And that's entirely unsurprising, we submit, given that it would be very odd indeed if you needed an individualised decision on detention, but not an individualised decision on the risk of absconding. Both risks, both issues would require individualised consideration. And again, one can take both of those elements, individualised in both contexts, from 46 of Omar, which is detention. I'm going to have to give you the references and move on given the time, but 46 is detention, and 39 and 40 are both interesting and good points on this issue, on the risk of absconding and the need for individualised decision-making on that front also. And that means, therefore, that the position cannot be sensibly to prescribe all the circumstances, all of the potentially relevant questions or criteria with an accompanying preclusion against reliance on anything else, which is my learned friend's case. There's nothing to that effect in Chodor, and it will be antithetical to individualised consideration of risk of absconding in particular cases. The fourth submission against exhaustive is that the basic principles governing legality, including the key aim of controlling overbroad executive discretion, can equally well be met by a system in which the criteria are non-exhaustive. It isn't necessary for the rules that govern to be the government of laws and not of men. The John Adams, the founding father quotation that Lord Sumption introduced in the P judgment, the Gallagher judgment. Fifthly, the exhaustive position is directly contrary to the additional points that were made and rejected in Omar by my learned friend Mr. Fordham. If you go to paragraphs 50 to 51, you see the first of them, which was, to cut it very short, that he accepted as that those paragraphs record that the proposed amending check legislation would do. That check legislation is set out in paragraph 50 in the quotation on page 3062, just between F and G, and you will see 4 lines into it, considered to be a significant risk of absconding, in particular, where, and then a series of things are set out. So that's non-exhaustive, but as they point out in paragraph 51, that was held up as an example of what would be lawful, and then they note the inconsistency. But the second reason that they refer to, the second point they make, is at paragraph 52, and that is by reference to the Commission recommendation, and that is the first of the documents in the little clip that I handed up. Given the time, can I simply ask you to sideline, if you would take that little clip to hand. This is about the return handbook, which the Commission publish under the return directive, as you see from the preamble para 2, and this is intended to update it, and it does so in the light of Chodor. And the annex that we're about to go to is the return handbook as updated, as one sees from paragraph numbered 1 at the very bottom of that first page. So that's what you're dealing with. Go to the, if you would, past the contents page to the first substantive page, and you go to the bottom of that. 1.6, risk of absconding is the title. So go beyond the contents page to the next one. If you, and then you have risk of absconding at the bottom of that page, paragraph 1.6. And you see the formulation that they're dealing with, that they're giving guidance about at the very bottom of that page. It's exactly the same as Article 2N of Dublin 3. Do you see the italicised last 2 lines on that page? And then they set out a list of criteria, effectively a list of criteria that member states can think about in the indented bits on the next page, page 92 going on the top page numbering, and then just have a look at the final paragraph on that page, according to the general principle of union law, and the particular bits that I invite you to circle, as it were, on the third line, taken into account, and 4 lines up from the bottom about halfway through again, must take into account all relevant factors, including the age. So that last sentence, take into account all relevant factors, are the factors in addition to the criteria that are listed. So they are deliberately and expressly allowing, unsurprisingly in context, for all of that. And indeed, it's very hard to see, sixthly and finally in relation to this, how an exhaustive list would actually work. And indeed, most of the time, the likelihood is that if there's a positive preclusion on taking into account anything else, you would end up in a position where the claimant or the person about to be detained would be worse off. Because the additional criteria or factor may be something which operates against their detention, or to reduce the risk of their absconding. Suppose a mother is terminally ill and in the jurisdiction. That would seriously diminish the risk of absconding. Could it be taken into account? On my learned friend's logic, no, but that makes no sense whatever. So far as risk of offending that my learned friend identified, to move on to a slightly different topic but related, as far as risk of offending is concerned and why it wasn't included in the regulations or whether it was included in the regulations, we respectfully submit that that's not a good point. It's far from clear that you couldn't take into account the risk of offending under the regulations. See paragraph 4C. And what that demonstrates is that actually you can just you could sort this problem or not sort this problem by the breadth of the criteria that you define. But the fact of the matter is that we don't accept that reoffending could not be relevant and could not be taken into account under those regulations. But even if not, there's no doubt a choice as to what to include in any questions. But there was very little argument on impermissible. He hardly developed any argument that it was structurally impermissible because set out in a binding policy of the kind we've seen. And for all the reasons I've given, that policy was binding. Can I very briefly deal with damages? So far as damages are concerned, and EU law, first of all, the fact-attain point, can I just invite you to look, if you go back to Byrne, which Mr. Southey took you to, Bundle 3, tab 37, page 2553, I think it is. He referred you to paragraph 45, which referred you back to a quotation from Evans. You need to look at paragraph 20 of Byrne, which recites and quotes Evans. And when you do that, you will see that there was no departure from the principles set out in fact-attain. Quite the reverse. It isn't soft-edged, and Byrne is positively applying and acknowledging the principal constraints that EU law imposes. My Lord Reid, just before coming to my Lord Reid, can I just deal with one thing in relation to my Lord Wilson and my concession, as it were, just in case I don't want to be hanged on a concession. Our approach to the balancing issue that I advocated in opening, our approach to that is squarely based on Lord Justice Sales's judgment at paragraph 140. That's our primary case. And what that paragraph imports is an acceptance that there is domestic unlawfulness if it doesn't comply with EU law, and as he points out in that paragraph, the possibility that that could lead to release. But he does not accept that unlawfulness of that kind undermines the detention authority for the purpose of the tort. So that there is
that's rather tiresome, Mr. Eady.
That's rather
Tiresome, because you did concede that.
well, my lord. I'm sorry if I did. Then I hadn't meant to.
No, okay.
It's a point of some subtlety because there is unlawfulness, which I do accept.
Yes, quite.
And the question is, where does that lead?
Well, quite. That's why I asked
yes,
for clarification.
I apologise, my lord, but I don't want it all to go off on a false concession.
No, okay.
Our argument is Sales 140, and that does draw that distinction, so that it doesn't undermine the detention authority for the purposes of the tort, and it's at that stage that you balance. And it isn't at that stage of balancing, if we get there, we respectfully submit, all very simple along the lines that Lord Reid was indicating. And that is, complication is never a good thing, I do understand. But the idea that one simply goes and therefore you don't need to confront the sort of issues that the court plainly was confronting in Lumba. The court in Lumba was plainly saying, you don't just go, as one would do in a commercial case, you don't just go to damages in a public law context like this. You ask the question that Lumba asked. And Lumba asked essentially the same question that Lord Hobhouse was asking in Evans, which is it just that damages should flow from this type of breach? And that does bring in the public law balancing. So, of course, here we are dealing with domestic law, but we're only dealing with domestic law because there is in relation to damages or whether the authority is constrained in some particular way, we're only dealing with that because there is a breach of EU law of a very specific kind. That's it. The premise for the damages is that the only breach here is EU law. And I do respectfully submit, therefore, that the answer to this is not simply to say, well, just because we're here dealing with domestic law and the tort of false imprisonment, that's the end of that. It still requires the court to address whether it is just, whether the balances that of the kind in a different context that they considered in Lumba should lead to damages at common law. Forget about release, that's the first part of Lord Justice Sales's paragraph 140, whether or not they should sound in damages in circumstances in which the CJU would not award damages for all of the reasons that I indicated. One final thing, if I may trespass for one more minute.
This is very unlike you, Sir James.
I know, I'm so sorry, but
you started early and you're finishing late.
I know. Nominal damages. One thing on nominal damages. I'm well aware of the court's concern, and I acknowledged in opening that there is no case which is directly on point. There is no case in which they have confronted the change in the law question. And I also fully acknowledge that that raises different issues of precisely the kind that my Lord Reid was putting to me. But my essential submission is that ultimately what we are here dealing with is a situation in which the right question is the one we described in our case and I described in opening. So you look to see what would have been the position if someone had acted lawfully. Then that raises the counterfactual. And the counterfactual essentially just asks what would have happened. Now, in very many situations, it may be impossible to answer that question in a legislative context, because the issue may be non-justiciable, because there's real doubt about it, or because you don't know what form the legislation would have been in. For a whole variety of reasons, legislation is a great deal more difficult on the facts, if that's what you have to do. But it's still essentially a hypothetical, counterfactual analysis. And here we know, and we do respectfully agree with Lord Wilson, that although of course we see the distinctions of principle, we do respectfully submit that it is absolutely plain as a pikestaff what would have happened here, because they did it. And they did it on the day the judgment came out. And all that they did, it was not to alter the form of it. There's still mandatory relevant considerations in the regulations, just as they were under the policy. They are exactly the same criteria to all intents and purposes, subject to the point about the crime or the reoffending bit, which we say is probably in any way. They did exactly the same thing. They just moved it as a matter of form from one legally binding state of affairs, i.e. public law, to another legally binding state of affairs, i.e. legislative format. And for that reason, it is not an affront to the rule of law to ask the factual question in our circumstances. I'm so sorry. 5 minutes.
Well, as I said, Sir James, it's very unlike you. I cannot remember an occasion where you've gone over time, but there we go. Some indication of the importance attached to this case, which, of course, we do understand. We will now go away and put our thinking caps on and let you all know the answer as soon as we possibly can. And, of course, we shall look forward to seeing you, if not hearing from you, this afternoon.